Hi, everybody. Welcome to class. My name is Curry Sautner. I'm the Chief Learning Officer at the National Constitution Center. Super excited to have you all in class today, because today we get to talk about my favorite amendment. I know we're not supposed to have them, but I love this one. And the reason why is it makes me think more than probably any other amendment that's in there. It really makes me wonder and what ifs all the time. And I think that's why I love it so much. So thank goodness we have the guy that's going to answer all of our questions, including mine, here with us today. So Tom Donnelly is our top scholar at the National Constitution Center. Tom, how do you feel about the Fourth? Do you love it as much as I do?
I don't know if I love it as much as you, Kurt, but I do really enjoy it, and I love teaching it. So it's going to be fun.
It's a good practical one, too. Like, you can see it in your life. You can see it all around you. So what we're going to do is we're going to dive into the words. Then we'll dive into some history of the Fourth Amendment. And then we're going to look at a hypothetical scenario. And also, I think I love it because it weaves in colonial history and modern application like cell phones all in 30 minutes. So much to do. And Tom, you know I always have a million guiding questions that kick us off. And I'll quickly kind of show our students this. And by the way, students, all of this can be found on our webpage. You can get every single slide that I'm showing you. And by the way, there's more. But the Fourth Amendment question, that's my favorite, that our students that we work with always ask is they say, can they do that? And they're usually, when they're talking about this in the Fourth Amendment, they're talking about a government agency. So my public school principal, my public school teacher, a police officer stops me on the street. But the real constitutional question comes down to, are they allowed to do that? And where in the Constitution do they have power and limits to do that? So Tom, kind of kick us off with that big idea, and then we'll start going through definitions and the actual Fourth Amendment.
Yeah, sure. That's great, Curry. With the Fourth Amendment, the big idea here is that before the government can search your home or seize your property, it needs a good reason. So it's a particularized suspicion as to a particular person. And you're right, it gives rise to a lot of really practical questions, like, can a police officer stop me on the street? Can they search my car, my desk, my nightstand in different contexts? Can they look at who I've called, where I've been, what I've written? And so the Fourth Amendment really ends up intersecting with a lot of things that we can relate to practically in our lives. And it's also the amendment that most governs our interactions, especially in modern America, with police officers.
Awesome. And you're right. It's like our deepest connection to the Fourth and to the government, and so many times, is police officers. So all those things really, really important. So let's look at the actual Fourth Amendment. And you're all going to laugh because, when I like to highlight things, I may have over highlighted it. But Tom, there's so many good parts of this amendment and that you can unpack. It's like a cornucopia amendment. Walk us through kind of what the amendment says and what it's talking about.
Yeah, sure. So let's begin with the words of the text itself. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. And so it's a lot of text. It's possible to sort of break it down into a few different parts. One, the amendment tells us what's protected. So what's protected here? Persons, houses, papers, and effects. Here, effects means our stuff. And so what are those things protected against? Unreasonable searches and seizures by the government. That's the core protection here. It's a protection against unreasonable searches and seizures by the government. Usually today, these cases involve police officers. And then we also have the second half of the Fourth Amendment. And that has to do with the warrant requirement. And so that's no warrants shall issue but upon probable cause. So this means that, if a government agent, usually a police officer, wants a warrant, that they have to clear that with a judge in advance, and they have to have probable cause. And probable cause, what does that mean? Well, it means that there's a certain level of suspicion of criminal activity. And so that's to justify a particular search, a particular seizure. It attaches to a particular person, place, or item, for instance. It's tough to really lock down exactly what it means, but it's less than beyond a reasonable doubt. It's less than even more probable than not. But there's a certain reasonable level of you're able to support it by a certain level of reasonableness that it's connected to a particular criminal activity. And so the last part there, Curry, and we don't often focus on it. If you want to just go back to the text of the amendment, but it's a good preview for our James Otis story is that, and it has to be supported by oath or affirmation, and particularly describing the place to be searched or the persons or things to be seized. And so here, the warrants that we have here after the Fourth Amendment, they're not general warrants. It's not the government can't say, we just want to go search everywhere for evidence of a crime. When you get a warrant from a judge, it has to describe with particularity the place to be searched and the persons or things to be seized. So our warrants are a really powerful thing. It gives government, especially police officers, the power to search our persons, houses, papers, and effects. But the Fourth Amendment has in place there this requirement of making sure that warrants are constrained and particularized to a particular person, particular place, particular thing, particular crime.
I think that's perfect. And thank you for pointing that out, that this strong direct connection to the Otis case, which we'll get to in a minute. There's one thing I want to say before we jump into these cases that we're going to go through. And you guys are bringing it up in the chat, and it's awesome. There is the Fourth Amendment in everyday life, and then there's the Fourth Amendment in public schools too. So we're really not focusing on the school cases in this discussion today because we only have 30 minutes, and that would be 30 minutes in itself. But I will definitely send you all some links to some really good school cases that you can look at that. TLO pops into my head, and the Stratford case is another one that I really like to talk about and kind of like unpack. And that was the Advil and the student. So a lot of, or ibuprofen, I should give the brand name. I don't know if it was actually Advil. So a couple cases that you can dive into after this and look at how do schools function around this and how does it work. So Tom, perfect. You really kind of narrowed us in that second half. They get so specific. So they add the Bill of Rights to the Constitution. Correct me if I'm wrong, but 1791, the Fourth Amendment is one of the amendments that's added, and they're really specific. So if you didn't know anything about it, and you see this, they're really getting clarity here, and they want to be very specific about warrants. If you get a warrant, you have to have another group of the government that approves it, and you have to be really specific about who, what, where, and when. Really clear. So it leads to believe like, wow, what happened that made them this worried about it? And that leads us perfectly to the story of Otis.
Yeah, so this brings us back to colonial Boston. It's 1761, and the British Empire has a problem. They're at war with France and they need money. The British Empire needs money to wage this war. It's looking throughout the empire, where can we get this money? And it looks to the American colonies. And it says, we've had these laws on the books that are supposed to, go at smuggling. These smugglers are supposed to be paying taxes that they're not paying. So let's begin to crack down on the American colonists, on American smuggling, and let's extract money from the colonies. The colonists have a lot of money. Let's begin enforcing the laws on the books, and as a result of that, help pay for this war against France that also benefits the American colonies. As a part of this push to enforce the anti-smuggling laws, King George III wants to use his royal officials in the American colonies to crack down on the tax evaders, on the colonial smugglers, with so-called writs of assistance. And so what's a writ of assistance? It's a royal writ. It's an order from the king that gives royal officials free range to break into the homes of colonists to search for evidence anytime, anywhere, and for any reason. So it's the complete opposite of what we eventually see in the Fourth Amendment, requiring that probable cause, requiring the clear description of the place to be searched and the thing searched for. And so, the American colonists are outraged by this, especially those prominent Bostonians who have a lot of money, who are big merchants, but are also smugglers. And so they end up calling upon James Otis, a prominent lawyer, a patriot, to take on their cause. He brings his argument all the way to the highest court in Massachusetts. And he said, these writs of assistance are unconstitutional. They're void. They're invalid. They shouldn't be able to be enforced in the American colonies. Why? Well, they undermine our rights as members of the British Empire. We are equal subjects of the British Crown. We are entitled to the same rights of other people in the British Empire. This violates some of the most core rights that we could possibly think of. Furthermore, it violates our natural rights given by God or nature. And it violates key principles like a man's house is his castle. And whilst he is quiet, he is as well guarded as any prince there. It violates the sanctity of our home. It allows royal officials to knock down our doors, search our houses, rummage around our stuff with really not any particularized suspicion as to us. The powerful argument here from James Otis is this. He says it is a power that places the liberty of every man in the hands of every petty official. When that happens, the rule of law, it breaks down. And our rights as American colonists are in the hands of every petty British official and their whim. That is not the rule of law. That violates our core protections, and it must violate the British Constitution. In the end, despite these powerful arguments, James Otis loses. The highest court in Massachusetts says, no, you lose. The writs of assistance are valid. But ultimately, Otis's legacy lives on. Part of the reason is that a young John Adams is sitting in the courtroom that day, taking copious notes, really excited about everything that James Otis is saying. And then later, as an old man, he would look back and say, Otis's argument was the, quote, first scene of the first act of opposition to the arbitrary claims of Great Britain. Then and there, the child of independence was born. And the Supreme Court itself, through the years, has returned to the Otis case to explain why it is we have a Fourth Amendment. Famous justices like Louis Brandeis have drawn on it in cases like Olmstead versus United States, which we'll talk about in a little bit. And also just as recently as a few years ago, Chief Justice John Roberts again returned to James Otis and John Adams's words in a case called Riley versus California, dealing with digital privacy.
Awesome. And we're going to dive deep into that towards the end. And now as we kind of like jump forward, there's a big gap in time where, you know, we don't see a lot of cases around the fourth, but it moves us forward and kind of brings us all into the 1920s. And we start to stretch technology and stretch this idea of where and what can be searched, seized, and taken. So that leads us really nicely to the Olmstead case. So Tom, dive us into this one and kind of help us understand what was the technology, what was the government looking for, and did they need a warrant?
Yeah, so we're going to go through three cases about phones. One in the 1920s, one in the 1960s, and one from just a few years ago. This one, first one, Olmstead versus the United States, it's 1928. So what's happening then? It's the age of prohibition. And so it's the government's attempt to crack down on alcohol. The government's using wiretapping of phones during this period to try to shut down illegal alcohol rings, illegal rings selling illegal alcohol throughout the United States to enforce the prohibition laws. And this particular case involves Roy Olmstead, who's accused of running one of these big illegal alcohol rings. So federal agents are investigating Olmstead, and without a warrant, they install wiretaps on Olmstead's phones, leading to his office, to his home, to the places of various other suspects related to his ring. And so when we're thinking of wiretaps, what does that mean? It's a real physical thing. So the government actually has to, get a line, physically tap in to the phone wires of the people who are using their phones. And so the government does this without a warrant. They tap into the phone lines using ground. They go underground under the public streets to get to the phone lines. They go to the basement of Olmstead's office building to get to the phone lines. So they're not breaking into his office. They're not breaking into his home, but they are physically wiretapping into the phone lines to try to hear these conversations. They listen in on the conversations of Olmstead and his associates. They find enough to find him guilty of violating the prohibition laws. And Roy Olmstead then comes to court and says, wait a minute. The government's stepping in here without a warrant to listen to my phone conversations. That violates the Fourth Amendment. And the Supreme Court ends up dividing 5-4 in this case. It's a closely divided case, tough issues requiring the Supreme Court to apply the Fourth Amendment to new technology. And it pits really two big figures of the Supreme Court against one another. The Chief Justice, William Howard Taft, who this is after his presidency. He finally has the job he always wanted for all of his life. He's the Chief Justice of the United States. He's writing the majority opinion in this case. And Justice Louis Brandeis, one of the greatest justices in the history of the United States, writing the dissent. So it's 5-4. What does William Howard Taft say? He says, Mr. Olmstead, you're wrong. You're reading the Fourth Amendment the wrong way. If you read the text of the amendment, it speaks of persons, houses, papers, effects. It's speaking really of physical, material things, not listening in on a phone conversation, but physical things in the world. And so Taft is really connecting to a broader tradition under the Fourth Amendment that connects the Fourth Amendment to property rights, to material things, not to things like listening in on phone conversations. And so if we're thinking of trying to summarize what would William Howard Taft say the key rule is here, If there's no physical trespass, there's no Fourth Amendment violation. So the government does not need a warrant, and Mr. Olmstead has to lose. So that's Taft's side. That's the 5. What about the 4? Well, the dissent is written by Justice Louis Brandeis. And what Brandeis does in his very powerful dissent is he really stakes out a challenge for the Supreme Court. He says the Fourth Amendment was ratified in 1791. Over time, we see a parade of new technologies come out requiring us to adapt old principles, old constitutional text to new technologies. When we do that, the key thing we have to do is to ensure, however we enforce and apply the Fourth Amendment, that we protect at least as much privacy today as the founding generation envisioned back in 1791. And so Brandeis warns the advances of technology are going to create a range of new problems. This phone situation is just one example, but it's going to get tougher and tougher over time. And so we see this powerful passage from Brandeis that Curry has on the screen. Progress of science and espionage is not likely to stop with wiretapping. Ways may someday be developed by which the government, without physically intruding into the home, might extract secret records and introduce them into court. This is Brandeis envisioning cloud computing. The idea that eventually all of our data might be out there, not in the physical universe, but just out there. And the government may be able to access it without breaking into our homes, searching, rummaging through our drawers, that there's going to be a way maybe where the government can get that information. And we have to be able to interpret the Fourth Amendment in a way that addresses those challenges. Finally, Brandeis says at the time of the framing, a far smaller intrusion, the general warrants that sparked the American Revolution, here he's talking about James Otis, were held to be unconscionable violations of liberty. Can it be that the Constitution does not afford protections against similar invasions in light of new technology? So again, Brandeis, what he's saying to Taft is, yes, you're making strong points there, Chief Justice Taft, but don't forget about the key challenge here. It's all about applying a Fourth Amendment that was ratified in 1791, old, broad constitutional principles to new technologies.
And what a good lesson, no matter what we look at. When we say and we talk about the Constitution still applies today, and it's not just this document from 1787 or 1791, it's about this theory that Brandeis spells out. Take the principle and apply it to today. Don't just, look at things from the past. Now, talking about things from the past, I can't help but lead into that way. A phone booth, students. This is a phone booth. So our next case is Katz, and there used to be phone booths all around that you would go into because cell phones didn't exist, and say you weren't at home and you had to call, get like a ride. You would walk in, you'd put coins in. My memory is 25 cents. You'd put a quarter in, and then you call somebody. But the thing is about the phone booths, and I don't know if this one shows it or not, most of them, you'd have a door and you would close the door when you went in. So tell us how this technology of a phone booth and the phones being all over the place changes this idea of expectation of privacy.
Absolutely. So this case involves Charles Katz. He's suspected of running an illegal gambling ring. So we have alcohol in the first case, with illegal gambling in this case. And what happens is he's carrying out this gambling ring in public phone booths. So he's going into the public phone booth, closing the phone booth door behind him, and conducting business, around his gambling operation to people in other states. And so with this, federal agents suspect Katz of carrying on this illegal activity. And what they do is, without a warrant, they set up an eavesdropping device in the phone booth, and it allows them to listen in on at least Katz's side of the conversation to figure out what's happening here. And so they listen in on Katz's conversations. They hear enough evidence that he is indeed running an illegal gambling ring out of a phone booth. And ultimately, they charge him, and he's brought up on charges for illegal gambling. And Katz steps in and says, wait a minute. The government didn't get a warrant here. They're listening in on my conversations. This violates the Fourth Amendment. And as you might expect, the government replies, what are you talking about, Mr. Katz? Have you read Olmstead? This here, you're not going after any of your private property. You're in a public phone booth. You're in the middle, of a public street. How could you expect any privacy? How could the Fourth Amendment possibly protect you here? And the Supreme Court, in a 7-1 decision written by Justice Potter Stewart, agreed with Katz. And what it does is it says Olmstead was wrong. It was wrong to limit the Fourth Amendment to physical trespasses and to just tangible things like that. Justice Stewart famously said that the Fourth Amendment protects people not places. And so here what he's talking about is that, Charles Katz, what he's doing is he is conducting his business. He has an expectation of privacy here. How do we know this? For the reason Curry said at the beginning, he closed the booth behind him, the phone booth door behind him. It may be in a public space, this phone booth, but by taking that gesture of closing the phone booth, he's creating a private space. And he has an expectation to believe that his conversations are going to remain private. As a result, Katz should win. We also have an influential concurrence in this case by Justice John Marshall Harlan, which is once again a really good example of, a reminder that when it's a landmark Supreme Court case, especially read all of the opinions. Sometimes the most interesting and most important opinions aren't the majority opinion, but they're concurrences and dissents. And here, Justice John Marshall Harlan looks at this case and he tries to create a new framework for the Supreme Court to analyze situations like this, where we're not dealing with someone trying to break into someone's house and search around their stuff, not dealing with physical things, but dealing more broadly with privacy concerns in society at large. And so what John Marshall Harlan says is that the Fourth Amendment inquiry here, the question of whether or not the government has conducted a search that could possibly violate the Fourth Amendment, the key question is whether there's a reasonable expectation of privacy. And for Harlan, he says there are two questions the court has to ask when asking whether or not there's a reasonable expectation of privacy in this context. One, did the individual have a subjective expectation of privacy? Did they seek to keep the information private? So this is the intention of the specific person. In the case of Charles Katz, it's that closing the door to the phone booth. The second question is, if so, was this expectation of privacy one that society would recognize as reasonable? And so this two-part test becomes a key way for the court to decide. If the court says yes to the first one, there's a subjective expectation of privacy. Yes, yes to the second question, it's one that society would recognize as reasonable. Then we say the government has conducted a Fourth Amendment search, and as a result, the Fourth Amendment then governs that case. And generally speaking, the government's going to need a warrant in order to search in that context.
Okay, so now I got a tech question here. So sorry, my brain's like spinning around these cases, even though I've heard them a million times. Okay, phone booth, phones, there's an expectation of privacy. But calling somebody on the phone back in Olmstead's day was very different. So like, I'm flashing to like Mad Men and like the old movies where like you picked up a phone, you called like the phone hub. I don't know what the real words are for these things. And then like Susie, the phone lady, like physically moved wires and connected you. Is this maybe a reason why TAP doesn't really said there's not a great expectation of privacy on the phone at this time? So us jackhammering into your sidewalk outside and tapping into it is, it's outside of your house, but it's also that it really isn't private on a phone line back in those days, or that really wasn't in play here.
I don't think that it was. It's an interesting question. I never really thought about it. But no, I think that Taft really is relying on what he takes to be the general understanding of what the Fourth Amendment covers, and that it's physical things. If you read Taft's opinion in the case, there's a large part of it that's an analysis. He makes a lot of the text, and that he just doesn't see the phone in this context and what the government's doing with the wiretapping as analogous to searching a person, house, paper, or effect in sort of like the paradigm Fourth Amendment case.
Got it. Okay. Sorry. I was spiraling around the fact that your calls back then aren't private. There's always somebody listening in it to see if you're done so they can move it to a different phone cord, which blows my mind how it used to work and how much people had to work into it. Okay. Next court case or phone case that we're going to talk about around this is Carpenter v. United States. So we can ask, so definitely a cell phone case. So no wires, no doors on this one. A very different way to look at cell phones. So it's not somebody talking on their phone and being listened to. It's how much data cell phones have on you. So Tom, why don't you give us the rundown of the case and try to hold back on telling us what happens, and then we'll do the hypothetical. We'll try it this way, okay?
Sure, absolutely. So this case it's a string of armed robberies. So the FBI is investigating them. One of these men confesses. He then gives his cell phone to the FBI. He also gives the agents the phone numbers for some of his accomplices. The FBI uses this information and the suspect's call log to get the cell phone records of many other suspects from the telephone companies. The key information the government wants here is the location data from these cell phones. So it allows them to figure out where these people were at various periods in time, but the government does not go and get a warrant in order to get this information from the cell phone companies. There are two reasons for this. One of them is that there's a law on the books passed by Congress called the Stored Communications Act, which says that in this context, the federal agents don't have to go and get a warrant. Instead, they can get this information if they say that the cell phone records were, quote, were relevant to a legitimate criminal investigation. So there has to be a relationship to a legitimate criminal investigation, but this requirement is lower than probable cause. So they're not going to get a warrant, they're doing it under this congressional act. The other thing is that there's a line of cases from the 1970s in the Supreme Court that lay out something called the third party doctrine. And so this basically means that if we have data and we give it over to someone else, that in that context, we lose our reasonable protection, expectation of privacy in that particular data. Those cases involve things like bank records and sort of phone logs of people who you've called over time. So in the case of bank records, you're then giving it to the company that's keeping those financial records. In the case of phone logs, it's the phone companies. And so if the government wants that sort of information over time under the third party doctrine, they don't have to get a warrant. It's not a Fourth Amendment search, and they could just request it from the phone companies or from the banks. And so in this context, the analogy would be for the government saying, well, this is data that people that Carpenter has given over to his cell phone company. And so the third party doctrine ought to apply in that context. Carpenter is eventually convicted. He's convicted. How long was his sentence? It's really long, to 116 years in prison. And so Carpenter then comes to court and he says, can the government do that? Can the FBI get my location data from my cell phone without getting a warrant?
And so students, you can answer in the chat now. So what do you think the court said? Can they do that? Can they go through, get this data, track you? And the general hypothetical is, can the government track you 24 hours a day, 7 days a week for an entire month using your cell phone data for location? This basically is what the FBI did with the data that they found, and they watched the movement and mapped out the movement for a month. Drum roll, please. Thank you, Colin. I appreciate that. The answer is coming in no. We'll give you guys 1 minute. No, and a lot of bated breath, just everybody waiting. Okay, Tom, tell us what happened. Can they do that?
This is another case. It's a really, really closely divided one. The Supreme Court divides 5-4, the majority opinions by Chief Justice Roberts. And he says that, in the end, Carpenter should win. In this context, the government, this is a Fourth Amendment search, and generally speaking, the government should have to go and get a warrant before accessing this information. The reason why is that it violates a person's, quote, legitimate expectation of privacy in the record of his physical movements. And here, what Chief Justice Roberts is saying is, sure, we have these cases about the third party doctrine. They have to do with bank records, they have to do with phone logs. But here, we do not want to extend that line of cases to this situation. For Roberts and the majority, this situation is simply different. Why? Well, part of it is about what the government can do with this information. He said it allows for a sweeping mode of surveillance that gives the government the power of near perfect surveillance, as if it had attached an ankle monitor to the phone's user. The surveillance is, quote, detailed, encyclopedic, and effortlessly compiled. It provides an all-encompassing record of the holder's whereabouts. And because of that, the Chief Justice and the majority here says, if the government wants that information, fine. But generally speaking, they should go get a warrant. But there are 4 dissenters here, Curry, and they make the arguments you might expect. Some of the justices, for instance, Justice Kennedy, says that this is a classic problem. The Fourth Amendment, again, ratified in 1791. We have new technologies. It's really fast moving. It's hard for the courts to keep up. And you know what? This is often doing this like line drawing, like this situation, applying things to new technology. That's something that legislatures are really good at. And so here we have a law passed by Congress that Congress thinks strikes the right balance between security and privacy. We should defer to Congress. And then some of the justices too, Kennedy, Alito, Thomas, they all also say, in the end, I don't think we should reconsider the third party doctrine. The third party doctrine should apply in this context as it would to others. Bank records are really sensitive. Phone logs are really sensitive. This is sensitive too, but in the end, it's analogous to the third party doctrine. And as a result, Carpenter should lose and the government should win. And so we see here, again, Curry, the justice is closely divided over a very tough question that again requires us to apply an old Fourth Amendment to a new form of technology.
Very fascinating, and also has posed a million questions in the chat, which we love. So students, I know some of you are in tight schedules. So what we're going to do is, as always, thank you, Tom. Thank you for walking us through all these amazing stories. But then we're going to do Q&A after this. So if you do have to jump, we understand, and you can jump at this time. If you don't, hang out and we'll get through some of your questions. I'm just going to do the official stopping of all the streaming